our law firm unapologetically stands up for the rights of the accused.
All right, here we go. This is sure to be the best part of my day.
I'm sure it will be. You're with the Mickey Williams, the one and only Mickey Williams.
Listen, I'm just looking at, so I have this notepad, legal pad, and I have just this word blame written on it. I'm like, what is this about?
Just draw an arrow to Capovilla, and then you'll be all set, no matter what happens.
Blame, dude. I don't know what that's about.
That's funny. Well, we are here. Robert Capovilla, Mickey Williams, and Matt Starosiak.
Yes.
These two are from the law firm of Capovilla and Williams,
That's
of
right.
course.
Mm-hmm.
But our topic today, we're going to talk about defending a sexual assault case today.
Right.
But before we do that, I'd like to say that in my experience, and I've worked with a lot of law firms over quite a few years, every legal case is important. Any legal issue that somebody has is important. Oftentimes, it's everything to them. But the reality is some firms do cases that are not as critical, not as important, not as earth-shattering as others, right? Somebody that incorporates a business, a small business is not doing something at the level that you guys are doing it, which makes it very interesting for me to work with you.
And I think stakes are high, brother.
The stakes are high. And I think it'll be an interesting topic today because what we're talking about literally is somebody's life being on the line.
That's right.
And so we're going to run through everything from strategy to your opinion on what an accused should do and everything in between. But but our topic is sexual assault defense in the military context. And I guess let me kick it off with the question. Somebody calls you, a service member from wherever they are in the United States or overseas, and they say, look, I'm being investigated or I've been accused of this crime. Where do things go from there for you guys?
Well, first, I want to get this message out very clear, right? Our law firm unapologetically stands up for the rights of the accused in military courts. I think we're in a battle right now where I am very fearful the rights of the accused are going to be forgotten. So I want everybody who listens to this to understand that unapologetically, this is where we stand. We believe everybody has a right to a fair defense. We understand the political nature of sexual assault defense, and we're not afraid of it because, quite frankly, Matt, false allegations happen every single day, whether Senator Gillibrand or whoever else doesn't want to talk about that. It happens every single day, and these guys need voices. And I've said that probably in every podcast we've had. But to go back to your question, we get a call. Typically, the first thing we notice is how scared, right? It's either mom or dad calling us or the soldier, sailor, marine themselves, and how terrified they are. And what we first want to ascertain is a basic assessment of the facts, where they're at in the process, and then really identify, even in that initial phone call, what is the theory of defense? And that really comes down to, if this person is being falsely accused, there's got to be a reason why, right? The accuser has to have a motive to fabricate. And this is where investigation early, before you're even charged, when you find out that CID or OSI is now looking into you, getting a defense investigator on your side out there talking to witnesses to develop your theory of the case early on becomes very important.
Is that because the evidence disappears? Is that because memories fade? Is that because the government's working on their case? I mean, what is the reason for an immediate investigation in an ideal case?
Because OSI and CID and NCIS and CGIS and all these organizations under the Department of Defense that investigate these kind of crimes, Matt, they have a very narrow frame and scope that they're working in. They are there to determine whether a probable cause exists. I mean, they can act like it's more complicated than that. They can act like it's broader than that. Really, they are there to determine whether a probable cause exists. And what gets forgotten in that, right? What gets forgotten in that is the theory of defense. It's not their job. So if you don't have somebody representing you who's got an investigator, a good investigator who knows what they're doing, then what's going to happen is the government's going to have 3, 4, 5, 6 months to build up their investigation. They're going to charge you, and then you're going to go, oh my goodness, there's evidence against me. What do I do?
Yeah, then you're behind the ball.
You're behind the ball.
Yeah.
You're behind the ball. So, step number 1, identify the basic facts of the case and investigate. Investigate.
Yeah.
Public defenders' offices are given 1 investigator per 4 attorneys, I believe. I think that's like the nationwide average across this country. They tell me there's investigators in the Army. I haven't met one. I don't know where they are.
Yeah.
And they tell me that Navy gets investigators, and I've actually met some of them, but I think by and large, a major problem with our military justice system is defense offices. Mickey, I don't know if you agree or disagree, but defense officers are not given the tools they need to investigate cases properly.
No, I remember one time, and this is at Fort Campbell when I was there. The judge would oftentimes, we would request.
Sorry, I get carried away. Takes me back to my glory days.
Yes, that's right. That's where they're located. But listen to this. So the judge, we would request to get a defense investigator. That's how the Army does it. And the Army's like, you can make a request for one, and then we'll see what happens. And the judge would say, what do you need an investigator for? You've got CID. They investigate both sides. Like, just go to them.
Yeah.
And so I go to them, and then CID would say, we're not doing it.
Happens all the time.
Yeah.
Happens all the time.
So that's the problem.
So there's no both sides.
No,
really.
they're completely not.
Unless somebody like you are involved in it.
And then what will happen is you'll call CID, you'll talk to the agent, and the agent will like, well, I got to talk to the prosecutor first before I talk to you, or the prosecutor will need to be here in this conversation if you're here. And I'm like, well, how many times have you talked to the prosecutor without me being present?
Right.
Come on, guy. Like, I mean, the whole thing, they're stacking the deck against the defense, and they're building their case from the very beginning. And Rob is right. You got to investigate, right? You got to develop that theory of defense, because ultimately what you're trying to do for the client is not have it go to a court martial. You don't want it to go to trial.
Sure,
You're trying to get it to go away.
Right.
And if you sit back and just let things unfold by the government, you're going to trial.
Is it fair to say that your cases, by and large, these kind of cases, these serious felony cases, sexual assault, are they won and lost on the investigation in many cases, or is that a stretch to say that?
That's a great question. So I'm going to answer it as best as I can. There are certain tenets that have to be satisfied, certain things you have to do to win a sexual assault case, and it starts with the investigation. You've got to identify the true facts of the case, because all law enforcement is going to be concerned about. They're going to interview your accuser. They're going to interview your accuser's best friend. They're going to interview the people that the accuser talked to. They're not going to talk to the people you want them to talk to. And to Mickey's point, I've had several times just this year where I'll want to go inspect evidence, and OSI or CID will say, well, you know, we can't let you in here. We got to go get the prosecutor's permission to do that. Well, who do you work for? We're neutral. You are? Really? You got to get the prosecutor's
permission. They'll say that on the
permission?
stand. Yeah, they'll say that on the stand all day, man.
Number one, investigate. That's your right. Do it, right? Or hire somebody to, well, don't do it yourself. Hire somebody to do it.
Yeah, we're going to get to that in a minute about what you should and shouldn't do yourself. But
if you're charged and you got it, and it's referred and you go to trial comes down to, in my opinion, an opening statement that gets your theory of defense out there and cross-examination of the accuser. People talk about closing arguments, the big moment. Studies have shown 80 to 90% of jurors have already made their minds up by closing statement, right? Closing argument. Get the investigation right, try to get it dismissed. If you can't do that, you got to nail opening, and you have got to have a lawyer who knows how to cross-examine, because if you don't, you're done. It's a wrap.
Mickey, how hard is it for a defendant to get a good investigation of their side of the story, of the truth, basically, but their side of the story, the way they perceive things, the way that the incident happened? How hard is it for them to get that?
Through the military?
Yeah.
That's impossible.
Yeah.
Like, you're not going to get it, man. You're not going to get, if you are going through the military to get the investigation done the way you want it to be done, if you're the accused, it's not going to happen.
Yeah.
You're going to have to hope and pray to God that your military defense counsel is doing their job to investigate it.
That's
right?
a scary proposition.
Well,
but I know you've had cases where...
And let me be clear. I'm talking about the Army. The Navy, I believe, does have defense investigators that will investigate.
So there's a difference between the branches on the competence of the investigation arm.
The Navy does a much better job. Now, here's the bottom line. Pre-preferral, though, before you're charged, you're technically not given an attorney in the military. They're not going to really work your case until you're charged. So even with the Navy and how good their investigators are, they're not doing much until you're charged. But at least there's been a cognizant effort from the Navy to do the right thing. The Army seems to still be under this belief, and the Air Force too, that law enforcement works for both sides, which is just utterly ridiculous.
Everybody knows that's not true.
Yeah.
Because it's not true.
Yeah.
It's not. it's just
certainly isn't
that,
true in
the Navy.
civilian.
Well,
No.
the Navy certainly has
Civilian
recognized that.
jurisprudence.
The Navy has recognized that,
And the Army apparently has investigators. We do a lot of Army cases. I've never met one. And I don't know if it's
Really?
because, no. And I don't know if it's because they think, oh, they hired civilians, they don't need, that's nonsense. We're a team, right? We work as a team with our co-counsels, our military co-counsels, and we got to put everything we have into it. And honestly, the pre-preferral time before you're charged is the best time to do the investigation because the prosecutors haven't talked to them yet, the witnesses, maybe the law enforcement hasn't gotten to them yet. We just filed a motion in a case, Army sex assault case, where we had our best investigator, Eric Eccles, phenomenal military investigator, on the case before preferral. And when we filed the motion and the government found out what we knew about the case, they freaked out.
Yeah.
Because all of a sudden this case that was shatterproof was kind of just shattered.
Yeah.
And, you got to do it.
But you guys have told me about instances where like key witnesses, real relevant witnesses were never even questioned or interviewed by anybody.
Right.
That's frightening.
Let's talk about E5 Fort Bragg 3 weeks ago. Okay. Get hired on a case. Without disclosing confidential communications, this is all this is all on the record now, right? This is all released now in writings to the chain of command.
Look at Mickey. He's like, huh?
He's looking at me. Don't worry.
I'm excited.
Don't
about
worry.
This
is all released.
His
Okay.
arms were spread and everything.
And this is a true. This is exactly what happened. Female claims that she was sexually assaulted. That's her right to claim that. Fine. Finds out there's 3 people in the room, including our client. 2 of those people are what we call CQ. They're people who are appointed for that night to make sure nothing goes crazy in the barracks. They are rotating in and out of the room the entire night because of how drunk everybody was in that barracks room. They are there all night long. CID does an investigation, okay? CID comes back, they talk to her, they talk to her friend, and that's it. There was no effort made to talk to these people who were in the room, who were actual eyewitnesses.
Yeah.
That would have been there all night long.
And are supposed to be monitoring.
Right.
Yeah.
CID comes back, they say probable cause exists to believe that the sexual assault happened. So the client hires us and our law partner Sean Flood takes lead and we're like, wait, what in the world? What about the eyewitnesses that are in the room? How could you come to a probable cause determination and not talk to eyewitnesses?
Yeah.
Well, CID then says, we can't find them. Well, they're active duty soldiers, aren't they? Yes, but we can't find them.
We found Bin Laden in Afghanistan or
we don't know where they were. Yeah, we get our investigator.
Find this guy in the army.
He's disappeared. We get our investigator on the case. He finds him.
Yeah,
talks to him. You know what they both say? Oh yeah, we were in and out all night long. There wasn't a minute where one of us wasn't in the room. And not only did we never witness a sex assault, they were sleeping in different parts of the room. One was on the bed, one was on the couch, and she never moved. Her clothes were never disturbed.
Yeah.
It never moved. And finally, after 7, 8, 9 months of being under the stress of investigation, they then decide we're not even going to give him a court-martial to defend himself. We're not going to give him a board to defend himself. We're going to notify him of a general discharge and kick him out. And we went straight to the commanding general on it. And we said, listen, this is not right. We fought it. And ultimately, hats off to the command. In the end, they did the right thing and they retained our client. But that is a true story. And if that doesn't scare you, Matt,
well,
I don't know what will.
It's encouraging that they did the right thing, but at what cost to that person? At what cost to your client?
Oh, there's a lot on the line for that guy.
Yeah, everything really, right? I mean,
well, the dirty secret out there that people don't realize, if they find probable cause for a crime, if CID says, oh yeah, we believe there's probable cause, you have now been titled, which means you will never pass another background check ever again.
Yeah.
They will always pop up. Right. And that's going to affect your ability.
I mean, sometimes the accusation is enough, right? I mean, we see that outside of the military as well. An accusation is enough. And
in some cases, it may be enough, right? I mean, it is true that most sex assault cases occur when it's just 2 people. And does that mean it doesn't occur? No, that's not what it means. But when we're talking about a legal standard, especially proof beyond a reasonable doubt, that can't be forgotten.
Yeah.
But anyway, so to get back to it.
But to back up, so client calls you, the investigation is key.
Right.
So then where do things go from there? Let's say you complete the investigation. Then do you start negotiating in some kind of deal, or the charges be dropped? Where does the case go from there? And what is your work up until trial.
So process works like this. Soldier finds out, airman finds out, Marine finds out they're under investigation. Then charges are either preferred or they're not. That's the formal charging process. And then in a sex assault case, you're going to have an Article 32, which is a preliminary hearing, which is turned into really an insignificant step in the trial, in the trial process, right? Very much like grand juries. And then after the Article 32 hearing, you have the referral process, right? And the referral process is when the case goes to the convening authority of the unit where the client belongs or the installation where the client lives. And that convening authority then refers the case, which means he literally or she literally hands the case off to the military judge.
Yeah.
There's more involved, but that's kind of the general process.
And that might all be changing soon. I think we talked about
Yeah,
that.
we had a podcast on what might be changing, but that all might be changing. And then once it's referred, you have your arraignment, your motions hearing, and then your trial.
Yeah.
That's the process, man. And I think your question was, what you mentioned something about negotiating with the prosecutors. So what they do at federal court is what's known as a proffer or reverse proffer. The best way, I think, to get these cases dismissed is to sometimes, if you've got evidence that's locked in, that's not going to change, tell the prosecutors like, hey, man, this is what we're going to do. Is she ready for this? We've got the Snapchat messages. Were you aware of this? Did you know about this? In the hopes that they do the right thing like they did in
So
in the
you'll
case.
put it out there
Sometimes.
Sometimes.
If the case merits it, right? Other times, it's I don't care. It just you really have to gauge when to do that because the prosecutors are sometimes trying to make their, I want to say their career, which sounds weird, but that's what they're trying to do. And especially if you're dealing with a sexual assault case, and then if you get the case dismissed from trial, it's usually not over.
Yeah.
There's other things that come about.
And so then let's circle back to the clients. We talked about kind of what you're doing and what your team is doing, but what about the client? What should the client be doing during that, from the moment they find out they're being investigated until the trial, the resolution?
Right.
What should they be doing? And maybe more importantly, what should they not be doing?
Yeah, I would say you tell them, Rob, what not to do because there's a lot of things
we could be here a while.
Yeah. Don't try to solve the problem on your own.
Right.
Okay. You're not qualified to do it. We have a lot of clients. Well, I'll go talk to this person. Nope. You can't do that, man. You are going to be staring obstruction of justice right smack in the face. Number 2, shut up.
Yeah.
Don't talk to CID. But certainly don't talk to CID before talking to a lawyer. There are some cases where we say, yeah, you know what? We prep the client. Let's get him ready for this interview. By and large, we don't do it.
Yeah.
Okay. I have a case right now, Matt. I swear on the Lord, this is the fact of the case. They bring my 22-year-old client in, kid from Ohio, near and dear to my own heart. Okay. And they lie. He denies everything. No, didn't do it. They lie to him. They say they have a video that they don't have.
Yeah.
And this 22-year-old kid starts freaking out. Oh my God. What? Oh my God. That's what you're going to run into if you try to do it on your own. So, with all due respect.
So they said they had a video. He starts second guessing himself.
Oh, dude,
and then they use that as evidence.
Whether you're an 06 or an E1, shut up.
Yeah.
You're not qualified to handle the case.
That means verbally, that means social media, right? Because obviously we're in a generation now that's coming up and through, and I know because I have daughters that age that, everything gets shared. Everything gets shared. Everything gets posted. Yeah. And they don't think about the consequences of sending a text message or a Snapchat.
No.
Right. It doesn't register with them the same way it registers with somebody. So none of that.
Well, just real quick. First of all, don't talk to the cops. I don't think anything good will come from it. They think, like, hey, I can go there. I can convince these guys, man. I didn't do this. No, you can't.
Yeah.
They're interrogating you because they think you're guilty, man.
Yeah.
So 99% of the time, never talk to the cops. 100%, get your lawyer's advice, right? Before that.
Talk to your lawyer.
But here's the problem if you do talk to them, right? Not only will they be able to lie to you, but if you're telling them the truth, you're telling them the 100% truth, and they don't believe you, they're going to charge you with a felony for lying to them.
Yeah.
So they can lie to you all day long. That's totally fine. That's investigation. Right?
Yeah.
That's what they go. We're investigating. You lie to them, you're now facing 5 years in prison.
Oh, yeah.
Just because you might have misremembered something or they misinterpreted what you said,
Yeah.
right? All these things. And that prosecutor is going to exploit that if you testify. He's going to say, you said this, you were lying. You were lying. It's like, no, that's not what I meant. Well, you just said under oath that you were honest when you talked to the cops, and then you came in here and you said that, blah, blah, blah. Like, that's what's going to happen. And then you're going to get slapped with what's called a false official statement.
Yeah.
And it's not fair because there are a lot of cases where the accuser lies. We have, I'd say 85% of our cases have some kind of untruth from the accuser.
Yeah.
They will never exploit that in 100,000 years. But I want to kind of go back to and tie this together, the investigation, right? Okay, client calls. We investigate. You identify a theory of defense, okay? What is the motive to fabricate? Evidence of consent, mistake of fact as to consent, eyewitnesses. You got to develop the heart of your case. And then you've got to turn them into themes and theories of your case, because if it's going to trial, you can't go to trial randomly. You got to have a theme and you got to have theories. So you develop through the investigation process. You develop through the referral process. By the time trial comes, your case needs to be broken down into the 3 or 4 things that you need to show the jury. Now, the burden's not on us, right? But you got to have that theory of defense.
You've got a case to present.
And I'm a fundamental believer that if you can present a case to a jury that passes the common sense test, you can win. What makes more sense? That this E6 sexually assaulted this girl in a bathroom at a dance club and he didn't know who she was, or that his buddy saw them dancing together and saw them go into the bathroom together and saw him and her holding hands and kissing? What makes more sense to the jury?
Yeah.
You identify the theme and theory. You lay that out in opening statement. And if you're going to put an opening, Mickey, you know this, you got to make sure that they're accurate and that you're going to be able to get those facts in cross-examination of the accuser. Because if you can't get it through the accuser, you can't get it through other forms, and you say something to the panel that turns out not to be true, credibility is king, you're hurting your client. Yeah. So every time I always say, here's what the case in opening, here's what the case is going to be about, theme, here are the 3 things we expect the evidence to show. Those 3 things I expect to get out during my cross-examination of the accuser.
Which must be a delicate process.
It is.
I would assume.
And you got to be good.
Yeah.
And then when you cross that accuser, you got to be exacting, and man, you got to be prepped. You got to have every statement she's ever made. You've got to have them compared. The second that the story changes, and it could be a he, right? He or she. The second that story changes, you got to be able to impeach on your toes, because that's what makes a trial lawyer. And if you can't impeach inconsistent statements, if you can't impeach through contradiction, if you don't know how to do those things smoothly, then let me tell you something. That client's in trouble.
Yeah. Yeah.
I wish Sean were here. If Sean were here, he would say, for his theme and theory, he'd be like, what is your Common Core experience with this?
Sean is your law partner.
Yeah, Sean is our law partner.
Sean would be talking all about Jerry Spence and the Trial Lawyers College. He'd be like, yeah, man, put it up on the wall, and everybody's got this kind of experience, and then
that's right.
There's trust and betrayal, and like you go all into
that's
it.
Right.
Man.
And hey, there's truth in that, but you got to investigate.
And then what do you do at that point? You trust the system to get it right? I mean, a lot of these trials are just in front of one judge, correct? Or
well, we do mostly panel trials.
Yeah,
and a panel composed of
a jury, essentially, right?
Yeah, I'm sorry. I guess these are terms we should explain.
Well, I think the majority of this folks will understand, but I'm not the majority of folks.
That's right.
Sure. So a panel's a jury.
Yeah.
There you go. Most of the time, you're going to take your case in front of the panel, right? Because it's much easier to convince a few folks. The government has to convince everybody. Well, three-fourths.
Yeah.
So, which we'll have a discussion about.
Yeah. That's come up in a number of our podcasts.
Yeah.
Versus just one person, the judge. And I oftentimes think that the judge, just like you look at the appellate courts, when they're always looking at what did the judge do for legal sufficiency, they're always analyzing, could a reasonable person have met all the elements? Could they have done that? And I think that's how judges look at cases. So if you're taking a case in front of a judge alone case, you're attacking one of the elements you're attacking the elements hard. And it's more of I don't want to say technical case, but it's more of a strategy.
Yeah.
And if you're able to do that, then the judge should find you not guilty. But the majority of the times you're doing like what Sean would say, the common core type deal. And you need that in front of the panel. And oh, by the way, your litigation skills, Sean, me, and Rob, like our ability to convince and persuade is going to be more effective, I believe, in front of a panel than in front of a judge.
Yes. I think with panels, when you're talking about litigating a sexual assault case, you've got to maintain credibility, and they've got to like you. I know that sounds kind of almost arbitrary or I don't know what the term is, shallow, but we oftentimes, people, and I've read studies on this through jury selection, things like this, people pick pretty quickly who they're going to root for. Yeah. If you turn on ESPN Fight Night on Friday nights and you watch boxers, within 30 seconds, they say people pick a side. Yeah. Okay? It's not that much different than lawyers. And if you're the civilian that goes in there and you're ripping and roaring and you're acting like you are the greatest, they're not going to like you. Yeah. You got to build that rapport with the panel. And it's harder in military court because you don't get as extensive ability to voir dire. So
questioning them before the case.
You got to be credible. When you list something out in that opening, if it's a theme or a theory or part of the three things that you expect the case to show, I have with me a log I keep, and I have my co-counsel check as we go so that I can make sure that the promises I'm making to the panel are kept. Yeah. Because what I've noticed is when I go through that list.
Fail on that.
Yep. When I go through that list at the end of trial and I've checked all or most of those boxes, I win.
All right. Couple more questions.
Sure.
First one, these cases don't just impact your client. They impact their families, right? To a large extent.
Oh, sure.
So what advice would you give to the family members, whose son or whose daughter or spouse is going through this process? I mean, obviously the most is support them, right? But I mean, what advice would you give, having talked with a lot of these parents that are going through this and their child's going through it?
Mickey, you want to take that one?
Sure. I wasn't anticipating that question, so
that's the kind I like to ask.
Yeah.
Remember that one podcast I asked what you guys like about each other? Remember that?
I remember that, yeah.
And it was like stone cold faces.
I said Mickey's biceps.
Like, yeah.
You're like, huh?
Who?
Yeah.
We're talking about my arms? Okay.
Yeah. You got nice arms, man.
Thanks, brother.
You do some curls, bro.
Well.
Looking good.
Thank you.
Yeah.
What I would tell mom and dad, and this is something
it's
that comes
most often
up,
mom and dad, right?
And it's usually
sometimes it's wife, husband.
Yeah.
But a lot of times it is mom and dad. Mom and dad are usually the ones paying in a situation like that too. So mom and dad, you talk to, I'm realistic with them, right? I don't want to take away their optimism, but you have to manage expectations too. Certainly, I think you said, support the accused, certainly. But also tell them what you think about the case. I would tell them, hey, these are the strong points. These are the weak points. If we're able to do this and we're able to convince them on these things, then we have a very good shot at winning.
Yeah.
If the government or the judge says we can't do these things, then it's a much tougher case. I would never tell them, and I don't think any lawyer worth their salt would ever say, we're going to win 100% guaranteed.
Oh, God, no.
Right?
Yeah.
No.
So you got to manage their expectations and be available to them.
Right.
Be available. I think that is very, very important.
Yeah, I have to imagine the emotional toll is a tough thing.
And you're a father, Matt, of daughters who, are of age to go to the military if they wanted to, right?
Yeah.
So what I think about is what mom and dad must be going through. Son, daughter, wears the uniform of the United States. They brag about these kids to their neighbors. They brag about these kids at the bars, the restaurants. A lot of times these are from people. A lot of times our clients are from families that, there's no college education, right? They've put their stock into their children to do well, and they're proud of them. And then all of a sudden one day it all comes crashing down. And that's something that we have to be aware of. I mean, they're facing sex offender registration, confinement. But I think what I want to second with Mickey on is you got to be honest with these people.
Yeah.
I don't know how lawyers would look themselves in the eye. I couldn't if I wasn't honest about what I see in a fact pattern. The other thing that I'll say is this. If you're a mom and dad and you're watching this and you're trying to find a good lawyer for your son or daughter, I don't know if we're the right pick or not. We may not be. Some cases we're not.
Sure.
I tell clients all the time, mom and dad in particular, you got to trust your lawyer and your son and your daughter's lawyer. You got to trust them because it is a fight. It is a fight. You're in the trenches together. And if you don't trust them, then they're not going to be the right pick. And I think that's key. And it's got to go both ways.
Like a lot of things in life, but certainly something of this magnitude, that trust is critical.
Absolutely.
Yeah.
Absolutely.
Well, good. Well, what have we left off that you think is important? Anything?
I would just summarize again to defend a sex assault case, right? First thing, investigate.
Yep.
Don't talk to the cops. Develop the motivation to fabricate. Make it rock solid, man. And build that opening statement and make good on those promises to the panel members. And then you have a strong case.
Yeah.
I think you're able to check those blocks.
Absolutely. And I think the only thing that we have left off, Matt, is I think Mickey looks great in that color jacket. What do you think?
Yeah, I think
kind of brings out his eyes. It kind of brings out his eyes a little bit.
It brings out the brown in my eyes.
Yeah, some of the sparklers he's got up there.
I appreciate that.
Yeah.
Well, Matt, you still look good. You're looking.
Thanks. I'm more.
The diet's going well, Matt. The diet is going well.
It's a work in process, I'll tell you.
Hey, Matt, are we going to get some Chick-fil-A after this podcast today?
You guys might. I'm not.
Do we have to edit that out now that we said that?
I mean, I support them.
Don't edit this out.
Well, listen, guys, delicate subject today, I think.
Yes, absolutely.
I mean, for you guys, I think you're right. You do what you do, and you're proud of what you do, and you're looking for fairness and justice. But it's an important subject, I think, for all of us.
Yes.
Especially me. And I appreciate your honesty today, and I think people will learn a lot from today's episode. So until next time.
Until next time.
Appreciate it.
Until next time.
Goodbye.
Signing off, gentlemen.
Out here.
Out.
This session is adjourned.